Okay, let's move on and look at the state and the union government. Now, Articles 239 to 241, which is Part 8 of the Constitution, deals with uh, union territories, and interestingly, each of these union territories are not necessarily having uniform administrative system. Which are the union territories that we are speaking about? We are speaking of the union territories which is there in the constitution. For example, Jammu is a union territory now. Kashmir is union territory. Ladakh is also union territory. But don't forget, apart from these, Puducherry continues to be a union territory. Lakshadweep is a union territory. Chandigarh is. Andaman and Nicobar is also a union territory, right? So right now, I think we have 8 union territories, as the case may be. Now, for the union territories, friends, as I told you, the union government is totally responsible. It makes legislations if necessary. It creates the finance and the budget structure. The services are also determined by the union government, and generally, the union government may also appoint an administrator in these union territories. Again, just to tell you that when it comes to the name of an administrator, again, there is no uniformity. For example, in New Delhi, which is now a state, which was earlier a union territory, the head or the administrator was called a lieutenant governor. So that is left to how the government in the union would want to decide. Uh, that's what is defined in the union territory. Now, what is the difference between a state and a union territory? Sometimes people tend to ask this provision in terms of what is the difference. Now, states, friends, have a state legislature. The union territories do not have a state legislature. So that's something that we have to understand. So there is a separate election for the constitution of the state government through what we call as members of legislative assembly. Sometimes it could be through the legislative council as well. So this is very clearly there in the state, but it's not there in the union territory. Uh, also, the union territories are quite centrally governed, and the president, through the aid and advice of, say, the lieutenant governor or the administrator in that place, takes care of all aspects, including police, public health, and others. Whereas you will notice that because there is the seventh schedule of the constitution, very often than not, anything that is done in the state government is entirely the prerogative of the state government. They are completely and absolutely independent in governance of their territorial land, and to the extent of the subjects that are granted to the state. And hence, you will notice that the state governments are independent in the legislative process and also in the executive process, and that is the kind of autonomy that the government enjoys in the states. So that is probably how the distinction has to be made between the union and the state, right? Of course, there could be differences between the union territories themselves. For example, between union territories that are island nations and union territories that are, like, say, a former French colony or a former Portuguese colony, as the case may be, like Daman and Diu, for that matter. So those differences can definitely be brought about because of the kind of aspiration those kinds of places or territories have. So that is some kind of difference that may be there in the union territories themselves, uh, and hence the confinement of what these are left to the Union of India. Also, there could be special provision for the administration of certain kinds of territories in India. For example, Delhi is a special territory in itself because while you have the Delhi state that is being created, because Delhi is so strategically important and situated. Why? Because Delhi is the place where the union government has its offices. So you cannot probably have state government make law for those kinds of offices that are going to be administered by the Union of India. So territorially, because both governments are in the same place, I think Delhi has this kind of a special status. It's not a full state, and you will notice that exceptional has been created where police and other forms of public order, the aspects of say conditions of civil servant, these are generally given to the state, but in Delhi, those kinds of subjects are entirely kept with the union government. So, public order, police, land, and civil servant conditions are not given to the state of Delhi. This is probably the kind of conflict that is happening between the current Delhi government and the Union of India. However, you will notice that the constitution was amended, and this has inserted special provisions to treat the territory of Delhi as a special territory. And while the elected legislative assembly in Delhi has jurisdiction on other subjects and areas like, say, public health, education, and others, which are usually what state governments are empowered to do, police is usually the entire domain of the state government. Unfortunately, in Delhi, the Delhi government does not have jurisdiction on police. This has been challenged multiple times in the court, and this has been kind of an issue that is, kind of a friction between the two political parties, that is the union government as well as the state government. Now, the lieutenant governor in Delhi is considered to be the president's nominee in administering public order, police, land, and the conditions of civil servants. So he can decide these aspects, right? So it is like having dual administration in the territory of Delhi, one partially by the union government, the other by the state government. Now, if they do it in some kind of coordination, that would be always very great. But unfortunately, sometimes it does not happen in that sense. Uh, so that's the issue in Delhi. And you will notice that the lieutenant governor is supposed to go by the aid and advice of the Delhi cabinet and the Delhi chief minister. However, we have seen in the past that this becomes a kind of a frictional problem between the two, because of course one looks at accountability to the central government, the other would want to have popular demand and popular public opinion, and would want to administer the same as well. However, I believe that the cultural, geographical, and economic stability of all states have to be ensured, and this, I think, is the responsibility of the Union of India. And the Union of India has to respect the structure of federalism in this country. And I think, in terms of cooperative federalism model between the state and the center, I think it's very, very important that issues like the issue in Delhi have to be resolved as early and as quickly as possible. And I think the law on precedent, the law on cooperation is the best method in terms of administering the territory of Delhi. Um, Fine. I think this is very, very clear. Now, you will also notice, friends, that union territories are not big territorial areas. They're generally small, easy to manage, but remember, they can be difficult as well. For example, the islands of the Andaman and Nicobar, islands. Now, Andaman and Nicobar Islands consist of many islands, and so are the Lakshadweep Islands, though Lakshadweep are smaller islands. But you will notice that some of these islands, then, as union territories, will have a capital. Like Port Blair is the capital of the Andaman and Nicobar Islands, right? Daman and Diu may have Daman as the capital. Lakshadweep also may have a capital. So all of these then become critical, because that is where the administration of the executive and say the lieutenant governor or the administrator of this place would be seated. That is where the administration of public policy will be done. And I think, see, in Andaman and Nicobar Islands, that becomes a critical part, because where the administration comes from, this place becomes also very important, because the place has to be accessible. The place also has to understand the cultural and ethical and ethnic issues among different islands, because many of these islands may be very unique with their kind of system. Many of them would be indigenous communities and people, so each of them may have a different food habit, may have a different cultural habit. So I think that kind of sensitivity of public administration would be required, despite the fact that Port Blair is in the southern islands of Andaman and Nicobar, right? Andaman and Nicobar. See, remember, Nicobar Islands are a different set of islands. Andaman Islands are a different set of islands, and Port Blair is the capital from these islands. Okay. Mm, uh, yeah. So I think the the status of union territory is important, because we have to agree that though they are union territories, the ministry or the nodal ministry for administration of the union territories is the Ministry of Home Affairs, and matters related to the union territories are decided by that ministry, right? So I think that is also critical and important. Now, uh, states are headed by the chief minister. The union territories are generally headed by an administrator that is appointed by the president of India. The states also have a union administrator in the name of a governor, but the governor is more a nominal head. That's not the case of union territories at all. So, governor is the union government's representative at the state, and the elected, person or the popular party has someone called the chief minister to administer the state government. So, these are some of those very interesting aspects between union and the state government, or the relationship between the states and the union territories as well. Uh, let's see if there is anything else that is required in this slide. I think we can move forward. Yeah, now coming to Delhi, friends, a quick discussion on the power tussle that is happening for a long time between Delhi and the center. This is actually a tussle that's happening from day one, from the time Delhi was created as a state, and in this case of NCT versus Union of India in 2018, a constitutional bench. Uh, they did look at what is known as the purposive construction of the Delhi Act. Now, you will notice that what is purposive construction? It is to say that, look, please see the objectives of the 69th Amendment to the Constitution. Now, the 69th Amendment to the Constitution looked at union government having some say in the administration of the state. But please note, when we say it is the union government has some role, it doesn't mean at the cost of the autonomy of the state government. So this kind of friction between state and the union is not good for development or for democracy. So I think Delhi is a very unique model. I think the model like Delhi is not there anywhere in India. So Delhi does not have a full state role, and that becomes a kind of a problem, because even the appointment of civil servants, transfer of civil servants, condition of service of civil servants is not with the state government, and they feel constrained in getting the performance from the civil servants as well. So the question is, how independent is the Lieutenant Governor of Delhi uh, on those kinds of aspects in which the union government has powers on, and also in terms of trying to coordinate with the state government. So I think the court has said that the LG is bound by the aid and advice of the Council of Ministers in Delhi, which is generally elected by the Delhi Assembly, and the LG must exercise his powers in such aid and advice only. And the Delhi government has to have all powers which are there in the state list of the seventh schedule, except three subjects. But rest of the powers, I think the Delhi government has, and the LG as a governor in any state has to approve the bills and give that kind of autonomy to the Delhi government. Uh, So the National Capital Territory of Delhi, unfortunately, cannot be granted as a full status under the constitutional scheme, and hence the constitutional bench has said, while keeping Delhi as a state, I think the kind of complete autonomy that the state demands may not be entirely possible. So I think the only way forward in this is, I think, what is known as the rule of subsidiarity. This is a foundational rule of any kind of federal approach, and this very clearly means that the sub-national governments, or what we call as the state governments, need independence. They need autonomy, but at what cost? Can it be at the cost of the strategic affairs of the state and the security interest of the state? May not be. And I think the cooperative model of the subsidiarity model is a very important model. And one must agree that the LG is more a facilitator. He is more a person who, joins hands in partnership with the state government. And he should not stand as an adversary to the local elected government of Delhi. That should be the response in which this should go forward. And I'm sure, while there is justification on both the sides for the betterment of federalism and democracy, and one looks at Article 239 AA of the Constitution to very clearly, get this exceptional rule of Delhi being a limited state. That is something that one will have to take due note and consideration of. However, please note the Union of India may decide to revoke the full or partial statehood to Delhi if this continues, and then later on, one would look at the Parliament's absolute power in reorganization of states. This is definitely possible. That is something that cannot be ruled out entirely. So that is also a very interesting dimension of union and its territories, or the way in which it has to be administered. As you would notice that there is so much of centralization of the union in India, and the constitution has deliberately allowed the union and the central government or the federal government the strength and the kind of constitutional powers it is required to ultimately decide in national interest, in the interest of the nation. So this kind of unity of diversity of states is something that the constitution always wanted to strengthen and advocate forward. So that is very clearly there. I think the diversity among the states is not an absolute, rule to secede from India. It cannot be a rule to exercise public policy which is not, which is in contravention of national public policy. I think this is very important for us to visualize. So you will notice that there are several provisions in the constitution where the central public policy has to be the dominant public policy in public administration. So it is national governance, it is national public policy that public administration are bound to follow. So wherever there is a conflict between national public policy in the public administration as against state public policy in public administration, I think it's very clear that the purposive rule of interpretation, the rule of subsidiarity, definitely recognizes the state public policies, but it has to be subservient to the national public policy. That is something that cannot be compromised. That is something that cannot be wished away with. And the Constitution has strengthened those dimensions from time to time. Finally, friends, to conclude, part one of the Constitution of India and this topic on union and its territories, it is important for one to understand that international law also governs territory of India. Now, looking at the territory of India on land and extending it to the sea, I have already told you that the United Nations Convention on the Law of the Sea, it is called the UNCLOS Convention, has laid down what can be considered as territorial waters, right? As students of law and public policy, these are some of the terminologies that you should be very well aware of. First is what is territorial sea. Second is what is a contiguous zone. This is something that is defined under the United Nations Convention. And please note, all of these determine what kind of law applies on sea. See, for example, we say the union laws will apply to the territory of India. When I say what is territory of India, one must look at horizontal territory, one must look at vertical territory. So will the Indian laws apply in the sea as well? This is a question that can often arise. And hence, these terms and terminologies become very, very clear. And also about the kind of process of public policy in these areas or in these sea territories. For example, there are a lot of movement of ships. Now, for example, we say territory is by road, which means the law can apply on road, and we can check the movement of vehicles. We can probably search seas for contraband and other substances. Can the same happen on sea? Can the Indian administration or public administration operate on sea? To what extent? Where? To what limit can we consider this to be the territory of India? Where does the sovereignty of the state extend to in sea, in airspace? Right. This is also some kind of an important process in understanding territory, as the case may be. So, what is territorial sea? I think UNCLOS very clearly defines what is a territorial sea, and it says that this is a place of nearly 12 nautical miles from the baseline. Okay, and this is a place where the coastal state, like India, being a coastal state, even in the islands, can extend its sovereignty towards. So one remembers a very interesting episode of the Italian Marines who actually shot two fishermen. And the question was, did they shoot in the territorial waters of India? If they did so, they would be amenable to the law of the land in India. But if it was beyond territorial waters, maybe they will be amenable to the law in Italy. So I think for many purposes, this becomes very, very important, which clearly brings us to light that territorial sea is the jurisdiction of a particular country, and foreign ships will have to comply with the law of the land. And please note, when I say foreign ships, this can include merchant ships, it can include military ships as well. Though we always say there is something called the right of innocent passage. So if you don't disturb the law of the land, if you are not infringing the law of the land, you can still use these territorial waters and territorial sea. However, if there is a threat to the national security of the state or India or the coastal state, then such kind of innocent passage can be suspended, right? So that is how the international law operates on territorial waters. So foreign ships have to be very careful entering territorial waters. They need permission, they need licenses, they need to comply, and any kind of illicit trafficking or smuggling or any threat to the coastal countries, the extended innocent passage rule will not be applicable, right? So these 12 nautical miles are Indian territory. So whatever is in the sea, the subsoil, the seabed belongs to India exclusively. The next term is called the contiguous zone. The contiguous zone can be defined as something that is, kind of a belt which extends to 12 nautical mile. It is where the coastal states, it is 12 nautical miles from the territorial sea. Please note it, not 12 nautical miles from the baseline. So this is additional 12 nautical miles. So it is 12 nautical miles is territorial sea. The contiguous zone is 12 nautical miles beyond the territorial sea. And here is where the states can control these kinds of areas to prevent any kind of an action or violation of their own land. This is what we call as the right to chase, so as to stop any kind of illegality being committed on sea. So this is called the right of chase into the sea. It could be for the infringement of, say, the laws on customs. It could be financial or any security or strategic fraud, or it could be violation of immigration laws as well. So nearly 24 nautical miles is where the territorial law can extend for the purpose of protection of the rights of the coastal state. And this is how international law provides for. Now, please note, this 24 nautical miles can include the right of the coastal state to prohibit dangerous substances, goods, something that is damaging public health or environment, say oil spill or any other kind of illegal fishing, sometimes can also be brought under the contiguous zone. So that is also critical in terms of the application of the union territorial laws into the sea. Then you have the exclusive economic zone, friends. It's a belt of water extending up to 200 nautical miles from the baseline of the coastal state. Uh, Please note, 200 nautical miles includes territorial sea and contiguous zone, and this is where the coastal state has the economic right to do fishing, mining, oil exploration, and marine research. The coastal state has this jurisdiction to protect 200 nautical miles for preservation and conservation of natural resources and the marine environment. The next is called continental shelf. It's an area, which does not exceed more than 350 nautical miles. And this is a place where the coastal state has exclusive right for exploring and exploiting its natural resources. So from 200 to 350, you can call it the continental shelf for economic activity. Drilling and exploration of some oil, offshore windmills, all of these are considered to be within the continental shelf. Final aspect is called high sea. These are, beyond the exclusive economic zone, and the high seas are open for all states. There is what we call as in the high seas the freedom of navigation, the freedom over, say, the vertical airspace. Please note, freedom to construct artificial islands if necessary, freedom of fishing, and freedom of scientific research. So, high sea can be considered as some kind of a common heritage of mankind. It belongs to everyone, but it should not be some kind of acquisition or capture by anyone. That is what UNCLOS would want us to believe, and everyone has a right. So far, so till he respects the coastal countries' rights as well. Now, high seas are usually a problem for slave trade and sea pirates. Sometimes, there is a lot of illegal trafficking and unauthorized, broadcasting and others. So, crime on the high sea, every coastal country that is using the high sea can intervene, and they can actually take action, and there can be international cooperation as well. Now, to conclude, please remember, when we have been speaking so much of, say, up to 350 nautical miles as your continental shelf, and 12 nautical miles as your territorial waters, it also means that this is the territory of India. This can be the extended territory of India. And hence, when there is a horizontal extension of territory, anything above that, which is called the airspace, which is called the vertical territory, is also the territory of India or the Union. So generally, under international law, one would say that airspace territory is, it's divided into actually several classes. Like we have class A airspace, then class E airspace, and though we have the international civil aviation organization that kind of defines vertical territory of a state in air, this does not have a very firm international convention. So please note, the vertical territory of Union of India is also its sovereign airspace or sovereign territory. And hence what happens on the vertical space is also the domain of the Indian law. So we can decide who can use our airspace and who cannot use our airspace. Um, Generally, you will notice that the sovereign airspace can be defined as ranging anywhere between, say, 30 kilometers to around 160 kilometers. This can be considered as the sovereign airspace. So, anyone using the same or anyone who wishes to fly over India is also flying over its territory. So sometimes we say that anything above 80 kilometers is beyond airspace, it becomes outer space. Anything below 80 kilometers is considered generally as airspace, which is under the territorial land and the sovereignty of that particular state. So that's generally the kind of division that's being made for the purpose of international law, for the purpose of management of territorial aspirations, laws, security, and other purposes, right? Yeah, so that's where we should conclude and say that the horizontal territory and the vertical territory are both very important. Extended territory and actual territory are also very critical and important, because finally, friends, when it comes to defining the territory, it is actually the administration of the governance, or what we call as public administration, that matters. Because remember, as a public administrator, as someone who defines public policy, when you understand what is the territory, where is the applicability of my public administration, you then decide what to do. For example, you can decide, should I look at some of these areas to prohibit certain kind of activities? So prohibition law is where you look at the territorial application of your prohibition law. Sometimes you are looking at restriction of movement or activities, then you must know what is the territoriality to which that restriction should apply. You may, in your public administration, define certain places where you want to issue certain warning for, say, military and other purposes, or controlled areas, as you would want to call them. Then you should know what is the territorial application of that kind of an area. So all of these are critical, and hence I think this topic on understanding territory, understanding the state and the union territories, and understanding the applicability of international law in defining the Union of India and its territory becomes very, very crucial part of this course on constitution and public administration.